we won't be able to hear from very many people.
One of the benefits to having the registry would be the issuance of cards. Right now, it's a very common thing to say is I have a medical marijuana card. Those don't actually exist from the state. This would allow doctors or other authorizing prescribers, physicians, to sign the patient up electronically over a secure web-based system, and then the Department of Health would maintain the integrity of the information and would issue cards to the patients that are signed up by their provider. We anticipate that the registry would be extremely secure, that we would ask that the information contained in the registry would be excluded or exempt from public disclosure. But we do think that it would allow law enforcement to confirm patient status if questioned. It would allow the department to track the numbers of patients for statistical purposes and allow boards and commissions to monitor appropriate authorizations by their licensees. There's a question that we receive frequently is exactly how many authorized patients are there in Washington? We have no idea. And that we also received the question of what providers are authorizers. We have no idea. This is a way of gaining that information. We would also...
Where's our privacy?
We will have our turn.
Go ahead, Kathy.
Christy. We would also ask that the authorizations have a date certain on which all existing authorizations would have a date certain on which they would expire to coincide with the implementation of the registry, so that all patients would then be seen by their providers and entered into the registry within a certain time of the registry going live. Any questions on that?
Thank you, Christy. I've had questions surrounding a couple issues having to do with privacy and the process here. So I'll just give them both to you, maybe you can answer them for me. One is whether federal HIPAA laws apply to medical marijuana. And the second one, I've had people pose the question. I take oxycodone, and I'm not required to be on a registry for that. I would imagine it has to have something to do with... You can leave off the applause, that way more people can talk. But, so, could you describe to me the difference? I imagine it's the difference in the prescribing process, but can you illuminate a little bit around that?
Well, I'll answer the first question first, which actually isn't much of an answer. We are not sure at this point how federal laws would apply, whether HIPAA would apply, because the federal government doesn't recognize marijuana as a medical product. However, state privacy laws would certainly apply, and we do have extensive privacy laws in Chapter 7002 RCW. As for the second question, it's actually incorrect. We have a prescription monitoring program that does track every prescription for controlled substances 2 through 5 that are dispensed in the state of Washington. We do have that registry within the state of Washington, housed in the Department of Health.
Model this after.
I'm sorry?
Go ahead. I just wondering, did you model the recommendation after the prescription process that we use for the drugs?
It's similar, yes, not identical. The prescription monitoring program actually has much more access than we anticipate this registry would have.
And Christy, am I right in assuming that every state except maybe California demands a registry for medical marijuana?
Every state has a registry. Not every registry is mandatory, but many states who have voluntary registries do have requirements that you have to be registered in order to have the benefits of arrest protection or an affirmative defense at trial if prosecuted.
Thank you. Thank you.
Questions?
And that will be different with our state.
We can't hear you.
We can't hear you.
Is it legal legalization impact the way in which you approach developing the registry?
It did not, because even though marijuana is legal for recreational use, it's only legal up to possession of 1 ounce, whereas patients would presumably, under these recommendations, have more than 1 ounce. So they would still need protection and proof that they were medical patients if they were questioned in possession of more than 1 ounce.
Thank you. And recommendation number 4.
Recommendation number 4 has to do with regulations regarding the healthcare professionals. The Department of Health currently regulates, license the healthcare professionals that can authorize medical marijuana, which is physicians, physician assistants, ARNPs, and naturopathic physicians. However, our regulation of them in terms of whether they are properly or improperly authorizing is complaint-based, and this is not an area where we receive a lot of complaints. So we would like to tighten up the authorizing requirements to ensure that real patients are getting authorization and recreational patients are funneled into the recreational market. One of the first recommendations is to define a few of the terms that are in the current law. In order to be a qualified patient, you have to have a terminal or debilitating condition. Debilitating is not defined. And all of the conditions that are laid out under the statute are actual disease states that are diagnosable states, with the exception of intractable pain. Intractable pain is not defined, and it is not in itself a disease. It is a symptom. We have found that this is most often misused in the cases that we do have in front of us, that patients are authorized for intractable pain when they do not in fact have debilitating or intractable pain, but chronic pain or periodic pain or lesser amounts of pain. So we feel it's very important to define those terms to give our practitioners some boundaries. We would also like to see comprehensive requirements defining the standard of care for treating patients with medical marijuana put into rule. So we would like the direction in the law to perform that rulemaking. We did this 3 years ago for prescribers who use opioids to treat their patients, and these rules set guidelines for the practitioners so they know what's expected of them, what the standard of care is when treating patients, in this case with medical marijuana. We don't believe that these patients deserve a lesser standard of care. We don't believe that they deserve a 5-minute cursory examination. We believe that if they have a terminal or debilitating condition, they deserve the highest standard of care from our practitioners. We also would like to see a restriction on the healthcare professionals' practice to ensure that their practice isn't consisting primarily of authorizing medical marijuana, but rather using medical marijuana as just one treatment modality in general practice. We'd like to see a permanent physical location for healthcare professionals' place of practice rather than hemp-fest tents and motel rooms on traveling circuits. We would like to see a requirement for in-person authorizations rather than internet or Skype authorizations. We'd like to see an expiration required on authorizations to ensure a regular cycle of re-examination and follow-up care. And finally, we would like to eliminate a certain provision that is currently in the law that allows for the public to petition for the addition of qualifying conditions. Currently, anyone can petition to add any condition, and a public hearing is required to be held, and the decision must be made within 180 days of the petition. These hearings are heard in front of the medical commission. They do not believe they have the expertise to make these decisions, and in fact, in the last 13 years, they have only granted 1 out of many and that was for chronic renal failure requiring dialysis, and it was a conditional grant. Changes can be made before the legislature, and they have been made before the legislature. We feel that that is the appropriate place for these decisions to be made, and so we would ask for that recommendation.
Are you through with that one part, Member Mark?
My question is that, so there are a set of medically indicated conditions presently defined in rule, in law, that would qualify someone for an authorization. So what your anticipation is that those would remain intact and not change coming into this new system necessarily. I guess there could be some new piece of evidence that came out, but that what you're proposing is that the rules around debilitating or intractable pain be changed.
Be defined.
Be defined.
Yes.
Okay. So, but other than that, the other disease states or conditions would remain the same.
Yes.
Are you going to require that there's collaboration, or that those qualifying conditions also involve the doctor and the naturopath and caregiver?
To collaborate on the treatment? That is something that could be addressed in the rules that I talked about in terms of what is the standard of care for treating a patient with medical marijuana. I think that that kind of detail would be better in rules rather than in the law, and that's something we could do in collaboration with stakeholders and the medical marijuana community to determine what that standard of care should be. But it certainly is in the opioid rules.
And then on the eliminating the provision allowing for petitions to add qualifying conditions. Sorry, not very good. So, on the petitions to add qualifying conditions, have you looked at other models in other states, or how did you come to determine how you make these findings? It seems like it's going to be a challenge with additional new research and how to, are you going to build some flexibility into the process as marijuana becomes legal and there's more real research and established? Was there any thought to how you handle that?
There is no thought in how it would go forward from here. We believe that that is a policy and a legislative decision. Currently, these petitions go in front of our Medical Quality Assurance Commission in collaboration with the Board of Osteopathic Medicine and Surgery, and they hear the petitions, and they do not feel that they have the expertise to make these decisions. And I am relaying the message from them to you.
So that's not something they're prepared to take under their own.
They have been having these since the late 90s, and they do not feel that it is appropriate for them.
Who are you to overrule a doctor's recommendation?
Number 5 is age limits. This is one of the things we were asked to look at, and it's also something we considered strongly under the DOJ memo because their first concern is keeping marijuana out of the hands of children. But we do believe that there are medical uses that are helpful for children, and we would not restrict use from children. However, in the initiative when it passed in 1998, there was a provision that said that the patient, the minor patient's parent had to be basically in charge of the minor's use of medical marijuana. And that was eliminated for reasons I still haven't clearly figured out in 2011. And we would like to see that provision come back because we do think that children 17 years or younger should be allowed to access medical marijuana with a parent or guardian's consent. and the parent or guardian should participate in the child's treatment. Authorizing healthcare professionals, if they're going to authorize to children, should be required to engage in frequent reexamination and follow-up with the child's patient and communication with the parent or guardian as well as any other healthcare provider. Keep in mind, these are children with terminal or debilitating conditions. They need to have coordinated, comprehensive care. We believe that the child's parent or guardian should be required to act as the child's designated provider and be entered into the registry as the designated provider. The parent should have, or guardian should have sole control over the medical marijuana. What we don't want to see is a 13, 14-year-old walking around with marijuana. The children make bad decisions, mine included. We don't want to open them up to peer pressure or sharing of their medicine. So we'd like the parents to have control over that and only give the child as much as they are going to need in the immediate time. And if medical marijuana is going to be consumed in a school setting, it should be controlled by the school personnel, the same as any other medications. But consistent with current laws, schools should not be compelled to accommodate on-site use.
Christy, I think I read in the recommendation, and I didn't hear you speak to it, adults 18 to 20 years old should be allowed to access to medical marijuana with proper authorization from a healthcare professional.
Yeah, this is someplace where 502 would have to be changed, because right now you have to be 21 to go into a retail store. Since we are recommending that the retail system be integrated into one, that would have to be changed to allow 18, 19, and 20-year-olds who are technically adults. We can't expect their parents to act as their provider at that age, but they would need to be able to enter these stores if they are an authorized patient with a card. And finally, on the next page, as I see this, there is one final recommendation that medical marijuana shouldn't be labeled in a manner that mimics candy or soda or treats that are attractive to children. And I have seen these products, and they do look very much like candy and other things that children like. And this is medicine, and we should treat it as medicine and not candy.
Number 6.
Number 6 is possession amounts. And the very first point I have, I'd like to clear up what I believe is a misconception. When the initiative originally passed, it said that a patient would be allowed to possess a 60-day supply, but it didn't define a 60-day supply, and that was a very confusing thing for patients and law enforcement and providers and everyone else. So in 2007, the legislature asked the Department of Health to define a 60-day supply in rule. And they also asked us to develop a report about access to medical marijuana for patients at that time. Keep in mind, this is 2007, 2008, it was before the collective gardens, before the dispensaries. So we did those two things in July of 2008. And it was very difficult then, and difficult now, to define what a 60-day supply would be, because everyone's needs are different. Patients have different needs depending on their condition, depending on their tolerance, depending on how they administer the medication. It was difficult, and it still is. Eventually, we landed on 24 ounces of usable marijuana and 15 plants. That was based on the fact that growing your own was the only access. It was the only way to legally have medical marijuana. And so there's, yes, it still is. And so it was tied to the growth cycle of those plants. Based on the growth cycle of those plants, you needed to start with 24 ounces to get to your next growth cycle. But it didn't say you could only have 24 ounces during a 60-day period. It means that's the most that you could possess during a 60-day period. When we looked at the needs of the new world, where marijuana will be sold in stores and be more readily available, will not have the same access issues. We thought, you know, what does a person still need to have 24 ounces at any given time? And we feel that they should not. That is a very large amount of marijuana to have in your possession at one given time. We, rather unscientifically, believing that the 24 ounces was still valid, did simple division and said, if that is a 60-day supply, well then 1/8 of that is the 1 week supply, and that's 3 ounces, and we think that is a reasonable amount. What it does not mean is that a person can only have 3 ounces in a week. It means that they can have 3 ounces at any time on them. In addition to the 3 ounces, we believe that they should be able to have additional limits for marijuana-infused products in solid or liquid form. Those numbers currently exist for recreational marijuana, and we believe that they should be at least the same or probably more than what is allowed for recreational marijuana. However, this is another place where we believe that we are not in the best position to make that decision, and we would like to see rulemaking for that so that we can have medical input and stakeholder input about what exactly it is that you need in infused products, in oils, in edibles. I will say that I don't believe that we will ever still have consensus. In 2007, 2008, it's not like everyone agreed on the 24 ounces and the 15 plants. There were a large number of stakeholders that were advocating for 71 ounces and 99 plants as a 60-day supply. My point being that whatever we set, or you set, or the legislature sets, however it's set, there will always be people who want more, who believe they need more, and you know we need to be prepared for that argument. Because we have certainly heard it in the past. We also believe.
I wonder if people could let Christy finish, please.
We also believe that now that there is a safe, secure, reliable retail market, or there will be soon, that home grows are no longer necessary, and they're not in the best interest.
I guess I want to ask you, do you want people to have time to testify?
You want it feedback? You got it.
You wanted this hearing.
The whole world's watching.
I'll tell you what.
The whole world's watching.
We're going to hear from people as long as you all stay polite.
Give her 2 minutes then.
Calm down.
They recognize marijuana as a medical product. It is medicine, and it should be treated as such. This includes rigorous production safety standards, informative and accurate labeling, and tracking for recall purposes. Ingestion of unknown pesticides, molds, chemical fertilizers, and adulterants are not consistent with good manufacturing processes for medicine. In addition, we believe that there are some other provisions that would help eliminate some of the confusion about this. We believe that we should require labeling to include levels of THC and CBDs to enable patients to make informed, intelligent decisions. We know that many patients want a high CBD product with low THC, and we encourage that. We want people to know what they're buying so that they actually have what they need. We want to restrict labeling and marketing, again, to ensure they are not intentionally attractive to minors. We would like to define plant so there's no confusion about what is meant by a plant, whether it's mature or seedling. And we would like to eliminate the ability for designated providers to also be qualified patients and thus possess double the legal limit of